half of co-ops allow trust ownership on their books, and the other half do not. For the other half that do not, there's a workaround. And the model for it is, in my will, if I leave you two as my kids, my Clearview Gardens co-op, do they have to let you live there? If you're in an amateur rock band and you collect feral cats as a hobby, they don't have to let you live there. But when you finally come up with a buyer that passes muster with the board, who's going to get the money from the sale? You guys, right?
Does it avoid probate?
No. I'm just giving you the model here.
Okay.
So there's a difference between the use and occupancy of the subject apartment. That is 100% under the control of the corporation. Then there is the question, who is going to get the ultimate economic interest? So what we do, we carve that out and we say, I, Anne Margaret Carosa, hereby assign my pecuniary, otherwise known as my economic interest in the shares pertinent to the Clearview Gardens co-op or whatever co-op we're talking about. I assign it into this asset protection trust. And that will start the running of this 5-year period for long-term care. Now, even some of the co-ops that do allow trust ownership, the folks decide to do this method instead of going through the board and having their attorneys charge several $1,000s to review the trust that you just paid several thousand to do. If your goal is to protect the value for long-term care purposes, this, what I call limited assignment, is 100% binding on long-term care. Now, to your question, does that avoid probate? Well, yes and no, because I scooped out all of the value. And the model for that is, if you watch daytime TV and they say, do you have a structured settlement that you would like to sell because you'll get all of your money at like a 40% discount, you can assign to these vultures your future right to the payments. And that is 100% binding. What I'm doing with my co-op, I am assigning the future economic interest to this asset protection trust. Now, the shares still have my name as the shareholder, and the corporation still considers it my co-op. So will it have to go through probate? Yes, but because I took all the dollar value out of it, it is now a small estate proceeding, which you don't even need a lawyer for that. It costs $1. And you transfer the shares.